about to get started, and Logan is the organizing Logan, sorry.
That's okay.
Good morning. Is organizing the food things. I'm going to let her make an announcement.
Okay. So, all of my fellow 1Ls, you guys I put together a sign-up genius over the break to keep Professor Hoffman's tradition of bringing food on Tuesdays alive. So everybody should have that email, but I didn't have the LLM's email address. So if you'd like to participate too, it's just something nice that we decided to do as a group, to keep the spirit of collegiality alive.
Well, and keep people
and
fed.
to keep us fed on Tuesday night. So I have a yellow list over there. So if you're interested, I'll email you tonight. I'll add you. I'll shoot an email with a link to the Sign Up Genius, and you can see who signed up for what. Really, it's not anything like you have to go crazy. Usually, I have 3 slots on there, and I said to put what you're bringing, but not really put what you're bringing. Like, are you bringing food or a drink? You know what I mean? Like, it doesn't have to be anything like that. So people bring sandwiches, some veggies, things like that. And so Michelle was kind enough, and she made some wonderful chicken tortilla soup for tonight. So,
in fairness, my husband does all of the cake, so I place the order and he delivers.
Anyway, the yellow sheet's over there, so if you want to just sign up and you can get it back to me by tonight, I'll add you to the list.
I assume your tradition is you wait until break for people to get food, or?
Either way.
Okay, so please feel free to get some food.
Okay, yeah, that's what we would do. Yeah, well, we would usually start around 5:30, and then people could start, and then we would have a break for sure.
Sounds
And
great.
then we're very attentive when we're in
This
class.
is way better than the apples and cheese I bring, so. Very responsible.
We're gonna leave you.
Yeah, exactly.
You.
I didn't do it. Okay. All right, let's go ahead and get started. Welcome back. Thank you for last night and all the information. I'm learning your names and such, and I will keep working on that. So we're continuing tonight. It's a double class. We're going to continue discussing a little bit about case process and how issues get brought up. And then we're going to talk about battery, and then we're going to talk about some of the other intentional torts and how they're related. So I want to start by going back to what was in the assignment yesterday. And I'm going to start circulating the assignment sheet, okay? And that, since apparently nobody in the middle saw it yesterday, I'm going to start in the middle. Just now, let's all make sure that it gets to every part of the classroom, okay? You're all responsible for that, so thank you. So going back to last night's assignment, the first part of the book basically is designed to sort of explain how these issues get to an appellate court in the first place. And it's probably good to think about a trial a bit like a story. First of all, have any of you ever been a juror? Anybody in this room been a juror? Well, your times will come. It's very interesting. It's of course, a privilege to serve as a juror. But cases have parts, right? They move in a certain way, and there are a lot of things to think about that, particularly as you're trying to be an attorney. So a case starts. A civil case is what we're talking about right now. A civil case starts when a plaintiff files a lawsuit. All right? The plaintiff will file a lawsuit. Now, you've had most of this probably in Civ Pro, but where the plaintiff files the lawsuit depends on the jurisdiction of the court and that sort of thing. We'll just assume for most of our torts cases that these lawsuits are being filed in trial courts of general jurisdiction in a state system. All right, so a Harris County Civil Court would be an example of that. So what the plaintiff does is goes to her attorney, and the attorney writes up what the plaintiff is complaining of, and brings that lawsuit. It's also called a complaint, right? A complaint, and the person bringing it is the complainant. So once that suit is first filed, then a copy of that suit has to also be given to the defendant, right, and the defendant's attorney. Then the defendant has their first chance to try to get the case dismissed. And that is, defendant can file a motion for a failure of the plaintiff to state a claim. Now, what does that mean? Well, as we're seeing in torts, and you're learning in other civil parts of law, in order to make a recovery, you have to satisfy certain elements or allege that certain things occurred, right? I can't simply go to court and ask someone for $5,000. Doesn't work that way. I have to have a legal reason for the court to order that person to give me that money. And yesterday we started talking about one, battery, right? So in that case, let's say I file a lawsuit for battery. I claim that, here, I'm trying to match all these things. Ms. Parikh, I'm suing you for battery, sorry. But what if my claim says that she committed battery because she accidentally fell over and hit me, right? Well, it turns out to make a claim for battery, you have to have intent. You have to the intent of the defendant, and it has to be an intent to do the unlawful touch. Well, if I in my notice say simply that she fell, right, or she accidentally fell, that it was negligent. Well, I don't even say it's negligence. Basically, if I don't correctly allege the elements of what I am claiming, then I have failed to state a claim. All right? So if the defense thinks that the plaintiff has failed to state a claim, they can file a motion to dismiss for failure to state a claim. Okay. It's somewhat unusual to get dismissed at this stage, but sometimes it can. And as we saw in our first battery case, which we'll talk about a little bit more, there are some bad attorneys out there who don't fully do the right thing. Okay, so then what happens? If you don't file a motion or the judge denies the motion, then the defendant must file an answer, all right? And that's where the issues are joined. So assuming that I have alleged an intent to do an unlawful touch, right, then the answer will agree or disagree with those specific allegations and bring up any defenses. So it may say that there was no intent, this or that, and that's the answer, all right? Then, once the suit has been filed and answered, either party can move for a summary judgment. What that is the party is claiming that, given what the defense or the plaintiff has said and the evidence they propose to produce, that will not be sufficient to prove the claim. It's kind of similar to failure to state a claim, but it waits until both the suit has been filed and answered before the decision goes, for instance. Okay, so we'll come back to these in a moment, but hold on to summary judgment. Then we go into jury selection. That's called voir dire, as they say in Harrison County. And it's a way to make sure you select an impartial jury. And things can happen there that aren't good, right? One opposing counsel could object to the other and say, you did an improper motion, or you said something improper, right? If you're doing things in the jury, and let's say it's a claim for battery and you've alleged somebody's hit somebody with a bicycle, you can't say, now, how many of you jurors would be angry to find out that the defendant has mowed down 27 children on a bicycle in the last year? Who would be angry? I just want to see if anybody's prejudiced, right? You can't do that, right? That's objectionable. Okay, so that can be a claim where you can object, and sometimes certain things can be so bad, right, that you have to start again or get a new jury or something of that nature. Okay. Then, when the trial begins and is going on, there are decisions that are made about what evidence will be introduced or accepted within the trial for the jury to hear or see. So, you all have not had evidence class yet, right? Or most of you haven't. So, it turns out that evidence is fairly, the concept of admitting evidence is actually fairly straightforward, although in practice it gets complicated. Basically, evidence is to be admitted if it is probative, right? It will shed light on the facts at issue, and that is balanced against its prejudicial impact. Right? So basically, anytime evidence is introduced, and evidence includes photographs, it includes physical evidence, it includes DNA samples, it can include witness testimony, all that is evidence. And the issue is the value of the evidence, its relevance, does that outweigh any prejudicial effect the evidence may have? What is a prejudicial effect? Well, if you watch a TV show, for instance, if somebody is accused of some grisly, well, not even, it doesn't have to be a grisly murder. Let's just say somebody's accused of some battery, and it's a serious battery. Well, you can introduce a piece of evidence that shows the injury, okay? But you probably are not going to get to introduce 30 pictures of the same injury in very gruesome detail, one right after the other. Right? Because after the jury sees what the injury is, seeing more and more just bloody pictures doesn't help them learn anything new. It just might prejudice them, right? So those things are balanced out. And so if you object, if you're an attorney and you don't think the evidence should be admitted, you say, that evidence is neither probative or it's too prejudicial, you file an objection. Again, you've probably seen on TV, objection, Your Honor, irrelevance, or whatever, objection, it's hearsay. That's another example, evidence you're not supposed to be able to admit, right? So then the judge has to rule on that. Then after that, after the case is completed, jury instructions are given, all right? And that is where the judge instructs the jury about what the law is. So if I were the judge in a battery case, I would say to the jury, the law in the state of Texas says that one person is liable for the battery of another person if that person intentionally inflicted a touch that was unlawful or harmful in some way. Okay, that's the law. And that's an instruction to the jury. Now, where do you think the judge gets jury instructions? The attorneys, okay, the attorneys. Good point, right. Sometimes it's easy to think that there's like a judge book somewhere that says this is what you do at every step of the way, but no. Trials actually operate basically by motions of the attorneys themselves, right? If the attorneys don't introduce evidence, that evidence isn't magically going to appear. If the attorney wants a particular jury instruction, the attorney proposes that jury instruction. So what happens is the judge will make a decision as to the appropriate jury instruction. So when a trial has ended, both sides will usually propose jury instructions. And sometimes they're the same, right? If the law is very clear, they might be quite similar. And yet, oftentimes, even if they correctly state the law, they may want to frame it in a way that's more beneficial to their client or not. Right? So my jury instruction might say, if I'm representing the defendant to be liable for a battery in Texas, the defendant must have intentionally tried or intentionally, inflicted an unlawful touch. Or intentionally inflicted an unlawful touch without the consent of the party, or intentionally inflicted an unlawful touch when the circumstances would not have suggested that such a touch was welcome, right? I may want to be spinning my own little story in the jury instructions, and the other side will too. All right, so what happens then is every single time a motion is made to a judge, right, the judge has to make a decision. And every decision the judge makes that is legal in nature then is appealable. All right? So if I move for summary judgment and that summary judgment is denied, I can appeal that. You know, appeal court, they should have granted summary judgment and this is why. If the evidence, I object and the judge admits the evidence anyway, I can appeal and say the judge made a mistake, they didn't apply the legal standard for admission of evidence, the decision needs to be reversed. Jury instructions, if I think the judge has misstated the jury or didn't accept my jury instruction or the one I wanted, I object to that, and that can go up on appeal as well. Now, once all of this is done, before the jury comes back with a verdict, a party, usually it's the defendant, but a party can move for a directed verdict. Basically, the party, they're just saying to the judge, look, you couldn't dismiss a summary judgment, but now you've heard and seen all of the evidence. And we claim that no reasonable juror could come to a decision against my client. So we want you to rule that. And the judge will say yes or no. Now, if the judge says no, the judge still has a chance to overturn the jury verdict because the jury can come in with a verdict and the judge, either party can petition for a judgment notwithstanding the verdict, and the judge may grant that, or could grant that. So in appellate cases, what tends to come up, the areas you tend to see in these cases are summary judgment, jury instructions, directed verdict, and J&OB. Now, all of those, I mean, there are some things about evidence, but those are really evidentiary questions. Usually they're not usually about the substance of the case. Although you can say the evidence prejudiced the case. But with summary judgment, that's always just about law. You assume the facts in the way most favorable to the non-moving party, and if the judge doesn't grant it but should have granted it, an appeals court will say that. And in so doing, they will say what the law is. They will say the law is battery requires intent to do a touch that is unlawful. And in this case, there was no evidence being proposed of unlawfulness of the touch. So the summary judgment should have been granted. Similarly, jury instructions. What are jury instructions? They're where the law is stated to the jury. So that's also where you get legal analysis from the courts of appeals. It was an improper jury instruction. And then similarly for the directed verdict. Now, what's interesting about all of these is every time you apply for one or when you're going up on appeal, the court is to look at it from a particular perspective and then to make this particular decision. So the particular perspective is essentially, could any jury given the law of this state and the evidence at trial, could any jury decide this, plaintiff should recover or plaintiff should not recover? Could a jury make that decision? Now, you might think to yourself, well, how would you have a judgment NOV? Because obviously the jury did make that decision. So how can you have a judge that say a jury couldn't make this decision? It's a bit ironic, but that's exactly what a judgment NOV is. You can think of jury trials and judges' supervision of jury trials as tension between sort of the elite judge and the representative of the people, the jury, that are not supposed to be particularly trained. And so, especially in torts, above any other common law area, the courts rely on the theory of jury common sense, if you will, to rule on the application of law to facts. So in a tort case, you're always supposed to try to let things go to a jury. However, if there is no claim, right, if the law is very clear, then it shouldn't go to a jury. You shouldn't even have a trial. Why? Because it's wasteful, right? It wastes resources, it wastes time. You shouldn't do it. And similarly, it's possible that jurors can have a bias or prejudice. So can judges. But this is most often seen, once again, torts and contracts in a way. There's often the idea that jurors favor the small individual, and they don't like big companies. So the theory is, what a juror might say, you know what, that poor woman was hurt, and that company has a lot of money, so they should just give her some money. And that's kind of a sympathetic idea, but it may not be consistent with the law. So in general, what you're going to see in all torts cases is defense generally tries to keep as much away from the jury as they can. They want the judge to make the decision. They want to get it out before it goes to trial. They want to get it out before the jury makes a verdict. And plaintiff, on the other hand, usually pushes very hard to get things before the jury, because juries tend to be more sympathetic to plaintiffs. Now, that's not always true. Obviously, it depends on the plaintiffs and the defendants, but that's one of the things that go on. So imagine then again, this trial is just a big, kind of back and forth between the plaintiff's attorney and the defense attorney. It's up to them to do all of this, right? They have to be on their toes. They have to be able to recognize whether the suit is filed correctly. They have to be able to answer the suit. They have to know when there might be a chance for summary judgment or not. They have to understand jury selection. They have to know evidence, about admission of evidence if you're in a trial or not. And they really have to understand the law for jury instructions. Okay? So that's kind of the way a trial will work. And as I stated, usually an appeal that we will see in this book, usually, will be from a summary judgment, jury instructions or failure to grant a directed verdict, essentially. And the standard for all those is, could a jury decide this or not? Reasonable. You're going to hear that term a lot. Reasonable, reasonable, reasonable. Are these people reasonable? Is the jury reasonable? Could a reasonable jury determine this? And remember that in a civil case, jurors do not have to be unanimous. It's usually just a majority. So, although states vary in what they consider is necessary to do that. Okay, so this is just set out at the beginning just to give you a flavor and so you understand where and how the cases are, where and why they are, right? So, any questions about this? Yes?
That sounds like the jury is overruled predominantly with respect to damages. I mean, that was the example you brought up.
They can be overruled either for liability or for damages. So,
I was looking at the tort element, like duty.
right,
Duty.
breach,
So in the,
causation,
I
damages.
guess I was only asking what the frequency of a jury being overruled breaches.
It varies a lot, and it varies a lot in the jurisdiction. I think you're right that the amount of damages is an example where things often get curtailed. But what we're really talking about here is more when the judges take away the decision at all. Like the judge is basically saying, there's not sufficient evidence for you to find that party A caused the harm to party B. So whatever you want to do, whether you want to make party A, give party B money, there's not enough evidence to support that element of the tort, or any of the other elements of the tort, for that matter. Other questions? Yes?
I don't know if I just missed this procedure, but directed verdict, how does that differ from motion for summary judgment?
Oh, okay.
Or does it matter? Is it just facts or?
No. So summary judgment comes before evidence is introduced.
Okay.
It's based on the evidence they claim they're going to introduce in the lawsuit and the answer.
Right.
So nobody's heard any evidence yet.
Right.
So at this stage, you kind of just have to take their word for it.
Right.
They're like, I'm going to be able to show you that so-and-so, Professor Flatt went off his rocker and we smelled the chicken tortilla soup and went on a rampage and ate all the food. But it hasn't happened yet, right? So you just have to assume that. Now, once we get down here, all of the evidence has been introduced. And all of the evidence has been determined, right? So now you know whether or not what I claimed I was going to do in my answer actually happened. So it's possible that I said something is going to happen, there's going to be evidence, so I avoided summary judgment, but then during the trial, that evidence never really happened.
Right,
And so now the other party can move to the direct verdict.
kind of like the other side of the evidence.
Yes, essentially on the other side of the trial, right? So, yes, this is what everybody said was going to happen, and in summary judgment, I'm claiming even if it does happen like they say, it's still not enough. But then this is actually after everything has happened, and I'm saying it's not enough. So I'm suing for directed verdict. Other questions? Okay, so let's take this and look at our first case, which we briefly discussed last night. Tessinier versus Schaefer. Now, as I started to say last night, and some of you said after you came out in class, this is a complicated or confusing case. So essentially then, so let's start from this and ask what is the actual objective. Well, first of all, who won below? That's always a good place to start, right? Who won the case below? Because you only appeal something if you lose it, so it's good to start out with who won. All right, so who won the case below? We can always tell that actually just from a term in the case. If you are the appellant, you lost below. Okay? You lost, so you're appealing, and that makes you the appellant. If you won below, you're the appellee. So, it says the appellant, Karen the Tessinier, was a teacher of art. Okay, so she lost below. She lost. So somehow below, the court decided what? She was the one that was suing, and she was suing for what? Battery. Well, negligence. There's the question. Okay. So she said that the actions that happened constituted a legal harm to her that should be compensated, and she lost. Right? She lost. Now, what's so complicated about this case is that probably she shouldn't have lost. If you smart students who have been in law school only one semester have been on this, I'm sure you could have done a better job than the attorney she had. So she shouldn't have lost, but she lost, all right? Now she's appealing. What is it that she's appealing? Remember, when you lose, you have to say the judge did something wrong. What is she claiming the judge did wrong below? Jury instructions, absolutely, the jury instructions. Okay, so what is it, this is where it gets complicated. The motion, so each side moved for directed verdict. The evidence, defendant's motion was predicated on claim that the evidence established a battery and not negligence as alleged. Now that's pretty dicey, right? I mean, for the defense attorney to say, you know what, yeah, she committed a battery, but guess what? You didn't claim she committed a battery, so yeah, you lose. And you don't get a second bite at the apple, right? So defense attorney's pretty smart. Like, hey, you went through all this to establish negligence, and you didn't. You established battery, but you didn't claim battery, so you can't win. Now, at the time they get up to the court, they have somehow managed, maybe they've talked to their old law school classmates, they've sort of managed to figure out what went wrong. And on appeal, the plaintiff claims the trial court erred in giving the following portion of the instruction on battery. If you find the defendant acted with the intent to cause a harmful or offensive touching of the plaintiff, and that offensive touching directly or indirectly resulted, then this constitutes a battery, and your verdict must be for the defendant, as this suit has been brought in negligence and not an action in battery. What's wrong with that instruction? We talked about this yesterday. What is wrong with that instruction? It's wrong. It's a misstatement of the law. I'll just tell you that right now. Why? Why is it a misstatement of the law? Yes?
Because there could be more than one court present, but this makes it seem like it's mutual.
Exactly, because the same set of actions can give rise to more than one tort. But this instruction makes it sound like if it shows one tort, it can't show another. That's not true. So it really didn't matter necessarily. Maybe they should have brought up battery, but this evidence could have also proven negligence. Right? Imagine, if you will, that the defendant or the plaintiff is claiming that the defendant accidentally pulled her chain. That it wasn't on purpose. Maybe it was on purpose, maybe it wasn't. Or maybe she didn't intend the touch, right? She didn't intend for it to fall. She was joking around. So she was just being negligent. She was careless. Certainly, a jury could find that. So that instruction was just wrong, and it was definitely bad wrong. Like, it was reversible error. Now, that doesn't mean the jury would have found negligence, right? Because you have to satisfy all the elements, and given this attorney, we don't know what kind of job this attorney would have done, but it's possible. Now, this is where it gets confusing. All right, so I've just told you right away, that jury instruction is wrong, and it's reversible. So why does the appellant not win the case? Yes?
Because the objection was not taken at the trial level?
Objection was not taken at the trial. Correct. It was brought up for the first time on appeal. Fair? No? Does the plaintiff have any remedy? Think broadly.
File a new lawsuit.
I'm sorry?
Could they file a new one?
Well, you can't, again, this res judicata basis that you can't bring the same lawsuit, but do they have another claim? Has somebody else done the plaintiff wrong? Yes.
A malpractice from the attorney?
Yes, a malpractice suit against the attorney. Exactly. Because this attorney breached, his or her duty of due care to be an effective attorney to the plaintiff. Okay. So, yes, it is unfair in a way, but that's kind of how the system has to operate. So that's an important thing for us to learn too. That's why you're always seeing these objections being filed, right? If you don't do it, you've lost forever. You can never bring it back up. So if I can object to the evidence when it's going in, I can't later say, oh, that was bad evidence. I can't do that. So you can look at trials partly as that's your chance to say what you think is wrong. And if you don't say you think it's wrong there, you can't then complain about it when you get up on appeal. All right? So, given all of that, we're learning a couple of things from this case about the law. We're learning, one, that the judge is wrong, that the same facts can't lead to both battery or negligence. The other is about the confusion over intent. Right? Apparently, the plaintiff didn't claim a battery because she didn't have to prove there was an intent to do harm. Does battery require the intent to do harm? Goodwin.
No.
There's a subtle distinction between intent to do something as opposed to intending that thing to do harm to the person.
Correct. Absolutely. That's all right. Go ahead. I can hear you well. Why not? I think it's the suit. It's the suit. Blame everything on the suit. It's good. I blame it. I don't know. I know how my dog feels like all day when I'm like cooking. Anyway. Okay. So there is a difference between intent to do the act and intent to cause harm. And that is the big legal principle about battery we get from this case. And that's, you're gonna have to say this to yourself over and over and over again. It is one of the easiest mistakes to make in torts with intentional torts of battery, is you just automatically get in your mind, they're doing something bad, they intended to cause harm. That's not it. It's not an intent to cause harm. It's an intent to do the act. Intent to do the act, not intent to cause harm. We saw in the notes, creepily, some professor goes up to a student and starts playing the piano on her back. Apparently he didn't intend to do any harm, and weirdly, somehow, there was all this like neurological damage, which again, I don't know how that happens. But nonetheless, he did intend to touch her, but it wasn't accidental. He intended to do that, and that what he did was not lawful, and it caused harm. Yes?
I'm still a little confused of how the act that she did could be both negligence and bad intentional act.
So as it turns out, the better way to say it is not that it could be both per se, but that it could be either. So how do I explain that? Let's say that she is just horsing around in the classroom, all right? And in her horsing around, she, is kind of flinging chairs here and flinging chairs there and just kind of having fun. She's just going back and forth, and she sort of sees the teacher and she's like, ha ha. She pulls this, and so there you can say there's intent, but you could also say that what happened arose from her just general negligence and recklessness. An easier case might be, what if she was drunk? Right? She didn't, the being drunk would be an unreasonable thing. So it's not about intent of battery, it's just unreasonable. But that might have been the cause. And so what you usually get with a case like this is that you allege both, you try to prove both, and let the jury select. And in fact, what you often do is it's called pleading in the alternative. So you say, defendant caused battery to my client. We believe the facts will prove that. However, in the alternative that you do not find intent, we believe that the facts will also prove negligence. So, by the way, below, and this is again what you got to wonder about this attorney. Why? Right? Were they that? They just thought, oh, battery requires an intent to do harm, so we better just go for negligence and not battery. Maybe, but that's really bad. Sometimes, actually, you will see a case where the statute of limitations vary for the cause of action. So have you ever heard of the statute of limitations? Right? There's a certain, that's it, bro. There's a certain amount of time that you can bring a case. Sometimes, in some jurisdictions, those may vary. An intentional tort might be 2 years, whereas negligence might be 3 years. So sometimes that is the explanation.
This is the explanation of this case.
Yeah.
Oh, is it?
Yeah.
There you go. So, okay. So we've learned that intent does not have to be intent to harm. It is simply intent to do the act. Okay. So let's look then at our next case, which I fondly call the Brat Daily Kid case. This is also, so if you've ever had this in any other torts class, you would have the different case. So this case came up twice to the appellate court. It's a very strange case. But there are some things to learn here. So let me just start out by calling on someone. Where's the sheet? Sign-in sheet come around yet?
Right here.
Everybody's had a chance, right? except for you. All right, thank you. Thank you. Now I look to see if said person is here and gave a check, and this person did. So, Miss Brandon, hello. You're 5 clubs. Basically, just what sort of theoretically happened here is really, I guess, the first question.
So we have the plaintiff, who is Ruth Garrett, and the defendant, who is a 5-year-old. And Garrett is suing for battery the 5-year-old. And so Brian was there to visit Ruth's sister, and Ruth went outside to talk to her sister into the backyard, and Naomi is the one testifying this because Ruth isn't saying what happened at all, but Naomi is saying that that Ruth went to sit down in the chair to talk to her, and Brian pulled the chair from under her. But
Okay, let's stop for a second there. Very good. Okay, so let's just stop there for a moment. So the facts as alleged by the plaintiff, this is a good place Sandy to start, are she goes outside, she's planning to sit, an elderly woman, she's planning to sit down, and this 5-year-old kid goes and just pulls the chair out from under her. She falls and actually breaks a hip, and he's very seriously injured, right? Okay. Now, so that testimony came from her sister, who was an eyewitness, right? So that was in the evidence. Now, there was testimony from someone else. Happened to be the defendant. And what did the defendant say happened?
so the defendant said that he came outside, and as soon as he came outside, he moved the chair and he sat in it. But he noticed that Ruth was trying to sit where the chair had been before he moved it. And so he immediately got out the chair and tried to put the chair under her, but because he was 5 years old, he couldn't move that fast, and she fell.
Okay. Two very different stories about what happened, right? So imagine this is the entire evidence at the trial. One witness says she goes to sit down and the kid pulls the chair out from under her. The other witness says, I tried to help and I went in the chair over. And she missed. And I'm a little kid and I couldn't do any better. All right, so only two. So now, one thing we learn about trials right now is that the trier of fact, can be a jury, can be a judge, determines the credibility of witnesses, right? And generally, that's not reversed on appeal, generally, right? And the idea is that the judge actually, or the jury, gets to hear them, right? So maybe, you can imagine, all we see is a transcript. But maybe her sister said, yeah, haha. Kid came over, took it out, right? Is that what you want me to say? Is that what you want me to lie about? Okay, kid did that, right? So we don't know. We don't exactly know what happened. Maybe the kid was very beatific and angelic looking, who knows? So the judge makes the decision, right, to believe that the evidence, the version of events presented by the defendant, which is perfectly fine. That's the role of the trier of fact. So given that, the question is, what is the legal problem with the court doing that? So it goes through what the judge found. It says, and it puts some in italics, the defendant, Brian Daly, moved the chair in question. He did not have any willful or unlawful purpose in doing so. He did not have any intent to injure the plaintiff or any intent to bring about any unauthorized or offensive contact with her person. So on appeal, the plaintiff can say what about that, those judicial statements? as a statement of the law of battery, what is wrong with that? Yes?
He doesn't have to mean to cause harm.
He doesn't have to mean to cause harm, right? He just has to mean to cause the touch. So in other words, this is important to learn. A battery can occur from a completely innocent intent. It really can, right? Because innocent intents can still cause harm, right? The intent is only to do the touch. So what the court then has to grapple with is this. If the judge believed his testimony, which is what the judge said he did, or she did, and he testified that he was trying to get the chair back under her, could that support the possibility that he intended to touch her? Maybe. We don't really know. It certainly doesn't preclude that he had the intent to touch her. Again, not with any bad, harmful intent. He could have been the sweetest kid in the world, but maybe he still had intent to touch her, all right? So this is where, and this is what the case then turns on. It is urged that Brian's action moving the chair constituted a battery. A battery is an intentional infliction of a contact upon another. You do not have to have the knowledge that it's going to cause harm. It's simply knowledge that you're doing the touch, you're intending the touch, okay? Or substantial certainty of the touch. Now, where this case gets really weird is what happened afterwards. So the appellate court says, you know what? You need to clarify this. You basically misstated the law. You need to go back, looking at your version of the evidence, decide, whether or not there was evidence to support the intent of any touch and go on from there. All right, fine. Then what happened when the case goes back to the judge below? Same judge.
Well, the judge found out that the lady had arthritis or arthritis, I don't know what you pronounce it.
Yes.
Yes, she was moving, she was trying to slowly sit down, and they really don't do that on purpose.
On remand, the Garrett trial judge reevaluated the facts. He stated that in order to determine what the kid knew, did he have the intent to touch or not touch, it was necessary for him to consider carefully the time sequence. Why he didn't consider that before, I don't know. But basically, he ends up rehearsing himself on the evidence that he believes, essentially. And so what happens then is the judge finds that there has been a battery, plaintiff wins, and that is upheld on appeal. So a very strange case. Again, weird things going on, weird judge going on. But we do learn again, and it's re-emphasized again, that you don't need the intent to do harm. You don't have to have a purpose. You don't have to have a purpose to injure or embarrass. You don't. It's simply the knowledge of the contact, the intent to cause the touch, the intent of the unpermitted touch. So, what does that all add up to? Well, if you look on page 20 of your book, you'll see the third restatement. Now, I don't know if you've seen restatements before. Restatements are interesting. They're prepared by the American Law Institute, which has been around for over 100 years. Our law school, U of H, has more members of the ALI than any other law school in the country, including me. And what they do is they have these very big projects where they look at all of the law in a certain area and try to state what it really is and clarify it. Sometimes that has the influence of pushing law in a particular direction. So you could kind of say they're both summarizing and saying kind of what it should be. All right? And for common law, that's particularly important because every state has its own system, but most of what we're learning will be the same, certainly in the uniform bar exam, but common law tends to be very similar around the country. All right? And so what they do with these restatements is they take all the cases that have come out and then try to find a way that, boils it down to a statement of law. And that's what they've done here. So it says, a person acts with the intent to produce a consequence. If the person acts with the purpose of producing that consequence, that seems pretty straightforward. Or the person acts knowing that the consequence is substantially certain to result. So that's a little wrinkle we haven't seen so far with battery. It's an intent to cause a touch or having a substantial certainty that the touch will occur. Right? Substantial certainty that will occur. Yes?
Isn't this relating to the case we just went to?
Garrett Daily.
Garrett. So the knowledge part, the court says there when Brian moved the chair, or if Brian moved the chair, he knew with substantial certainty that the plaintiff would attempt to sit down.
Yes.
Then the battery would be established.
Yes.
So it's not necessarily knowledge of, I guess, touch so much as it's just knowledge of consequence. That's what you were saying.
Well, essentially, you can look at it this way. Is the act you are doing likely to cause this unlawful touch? And the words they use are substantially likely. Right? And that matters in some cases. So for example, firing a gun, okay? Firing a gun in the woods, say you're hunting, and it hits a person, then you probably didn't have that intent to hit that person, or maybe it was all an elaborate ruse on Masterpiece Mystery to kill the person in the hunt, but maybe you did it. Okay. But now change that slightly. Say you're in a city and you're firing off guns on New Year's Eve. Maybe you're even firing them into the air. Is that a substantial certainty that touch will occur again? I'm not, maybe not. Now, if you're firing in a crowded building, the certainty jumps up quickly. Right? So you don't let a person off the hook just because they say, I didn't mean to shoot her. I was just shooting, I didn't intend for that bullet to hit her. But if there's a substantial certainty that it would occur, that's the same. Right? So it's the intent or the likelihood of substantial certainty that the act will occur. Now, if you, the third restatement, if you look under that, the actor intends to cause the contact, or the substantial certainty. The conduct that causes the contact, you can kind of pull those together. And the contact is offensive or causes bodily harm to the other. Offensive or causes bodily harm to the other. That also requires a bit of a dive, right? You can sort of imagine that the world exists with everybody having the right to tell other people they can't touch them. And that kind of comports with how we tend to think of individual liberty, right? I get to choose that. And so if you intentionally cause a touch, right, you're risking something, okay? Now, sometimes that touch is permitted because of the circumstances. We'll talk about that momentarily, and there's also defenses of consent and all sorts of things. But even a so-called innocent touch, right, perfectly innocent, if it causes harm, you can be liable for it. This is actually, you may have heard of the term eggshell plaintiff. So you may not intend to harm somebody, but maybe that person is very sensitive to something, right? And you do end up causing harm. The only question is, did you intend to touch them or not? That's it. The intent to the touch, and the touch is either offensive or harmful. You're going to see, again, as we said yesterday, there's going to see a lot of terms with this. You'll hear offensive, lawful, harmful, unauthorized. I mean, there's just many, many ways. But the simplest way to think about it is whenever you touch someone, whenever you intend to touch someone, that's all you need to establish a battery. You know, unless there's defense or unless the touch is warranted. See, you just did it. He did. The problem is, or maybe it's not a problem, I guess it's a good thing, he didn't hurt you. So you have no damages to sue for.
Talking about that, when you do poke him, and he's the eggshell client, and something terrible happens to him, but you weren't substantially certain that that was going to
That's
happen.
all you have to be substantially certain about is that your touch would occur. Not that harm would come from it. Just substantially certain that the touch would occur. Now this is where Torts starts to really, you know, you're starting like, ooh, I've got to rethink everything I do now. I don't know. No joshing with my classmates, right? So, you know, and from now on, by the way, for the rest of your entire lives, everywhere you go, you're going to see torts. Potential torts everywhere. You're just going to be like, I can't believe, like, your backpack was in the row right there. I almost tripped over it. Who knows what could have happened? So, in your defense, you could say, but I had no notion, no reasonable person would think you would go walking around the room. That's just crazy, right? So, okay. Anyway, so that's the key issue with the intent and with the battery. Now, look, if you will, finally, for the restatement on page 23. And this further defines what offensive can mean. Yes?
One last question. So if you punch someone, but it doesn't cause them any harm, will you not be liable for, if you want to bring that up?
Okay, here's a good, so I was a little facetious when I said no damage, so no harm, right? Technically, you could sue for battery. With intentional torts, the courts do recognize an affront to personal dignity. Now, how much that's valued is another thing. But for instance, let's say you had some annoying neighbor who's always like doing this, and you're like, stop. And you know, you could go the criminal route, you could get a restraining order and do all that stuff. But maybe you really are like, I'm gonna sue you for doing that, so you won't do it anymore, right? And you may not be physically hurt, right? But you still have that. And particularly for certain kinds of touch, like sexual assaults and other things, you may not have monetary damages exactly. You likely will, but you may not. But that still is clearly an offensive contact, right? And so the question is, what would a jury do? What would they think? This is why you leave it to the sort of common juror. And in the restatement, it tries to be a little more specific with offensive, right? It says a contact is offensive if the contact offends a reasonable sense of personal dignity, or the actor knows that the contact seriously offends the other's sense of personal dignity, and it is not unduly burdensome for the actor to refrain from causing the contact. So with the touch, you have two categories. The touch causes actual harm, right? You don't have to intend the harm, it just causes harm, like the guy with the piano in the back. And so you're liable. It just caused harm, it's harmful contact, you're liable. You intended the touch, you're liable. The other is an offensive contact, right? Which may or may not cause damages, but is offensive in the sense that either an average person would be offended, or you particularly know this person would be offended, and you can't avoid it. So notice it's almost trying to get to all of these things that happen in your everyday lives. Imagine you're in a crowded elevator, for instance, right? Most of us probably try to avoid touching other people, generally, I think. But sometimes you do. You can't necessarily help it. Generally, you don't know these other people, so that's not something most people would reasonably be offended by because it's just how society works, right? So, you know, there's not a bright line, but the restatement tries the best it can to clarify what that is. And again, you have to think about in the real world, who's going to bring a case, right? You're going to bring a case if you really do need to recover damages, for sure. And you're going to bring a case if you need to make a very important point, or a point to yourself about your own personal dignity, right? Those are the things that you will do. So that is then the essence of battery. You know, the intent of an unpermitted touch, just imagine most people are always, unless they indicate otherwise, the message is hands off. Yeah, so, yes, sir.
It is a little bit confusing to me, but for example, an accident can be categorized as a battery. Because, for example, if I open the door and someone is behind that door and I hit you in the face with the door, that's an accident.
That is
But
an accident.
I willingly open the door, intentionally open the door, and cause harm to you.
You're getting to the causation element. Right now, we're just looking at the breach of duty element. You intended to open the door, yes,
Yes.
but you did not intend that door to touch someone or have a reasonable certainty that it would touch someone. Therefore, it would not be a battery. You wouldn't have the intent element, right? You intended to open the door, but you did not intend for there to be a touch or substantial likelihood of a touch. Therefore, you move more into the negligence realm. You know, was it negligent to open a door? Most cases, no, it's not. But sometimes, maybe there's signs saying, be careful when you open this door. You've seen those signs in places, right? And you're just like, what? You know? Yeah. Like who? Cruella. Evil Cruella. That's correct. That is correct. But again, think through those examples, because that's really kind of how you start to figure that out. It's important to think through it. Again, it's a hard concept to get, I think, sometimes. It's just much easier to think, okay, this person should be sued in their bad because they intended to hurt somebody. But that's not the essence of the tort of battery. It's the intent to cause the touch. All right? Yes?
I'm confused a little bit about the damages.
Yes?
So in a battery, if you don't have damages, there is no battery?
Well, yes. Okay, so there are 4 elements of a tort. Every single tort has 4 elements. Duty, breach of duty, causation, damages. With intentional torts, damages are assumed. Meaning the plaintiff doesn't have to come forward with proof. The fact that it occurred means the plaintiff was damaged. So what we should distinguish, if this is helpful, is the term damage as an element of a tort, which is simply what it is. It's an element of a tort. And damages, which we normally think of as money things that you pay, right? So normally, in order to recover for a non-intentional tort, like negligence, you must prove there are damages. You must actually prove that, right? Evidence. Here's my hospital bill. You know, here's a photo. Here's the insurance payment. This is all I had to pay for this.
So, for example, Professor, going back to the case that the plaintiff failed to prove the intentional battery, right? And then if you find, okay, if you don't find the intentional, then this is going to be negligence. So, like, introduce that evidence.
You would have had to have introduced that evidence as well, right? So what you're doing is you're telling the jury, you start telling them up here. You say, I think I can prove battery, but in the alternative, I'm going to prove negligence.
Yes.
And so then when you do present your evidence, if you really want to, if you think you're not going to succeed on battery and you're going to need negligence, you better prove your damages. That's your only chance to do it. Right? You have to prove each element. Okay. Now, I want us to segue, we're not leaving battery completely, but we're segueing for a moment into assault. And in particular, the Vedder v. Morgan case. So tonight we're going to sort of finish up our look at intentional torts with looking at the 3 other ones that are likely to come up. There are some others. Trespass is the most notable one, but that's on land, that's a property issue as much as anything else. So that leaves us trespass to chattels, assault, and false imprisonment. Intentional infliction of emotional harm we're not going to talk about. That is not tested on the uniform bar exam. So assault is interesting because it can be a little more complex than battery. And this is how. Before we go to the case, let's start with the note number 2 on page 25. Like battery, assault is an intentional tort. The plaintiff must prove that the defendant intended to cause apprehension of imminent harmful or offensive bodily contact, or intended to cause harmful or offensive bodily contact. Now, look at just that second part. That's an or statement. So either one of those can satisfy the intent element of assault. But look at the second one. A plaintiff must prove the defendant, I'm just going to the second one, intended to cause harmful or offensive bodily contact. Now, what does that sound like? Battery. What's the difference between that and battery? The contact didn't occur. So one of the best ways to think about assault in the first instance, it's an example of the attempt to do a battery, but it doesn't happen. That's why you often hear those terms together, assault and battery, right? Because think about it. If you satisfy the elements of battery, you automatically satisfy that element of assault, right? If you intended to cause a harmful or offensive touch that occurred, then you still intended to cause the harmful or offensive touch whether or not it occurred, right? But you can't get double damages. I mean, essentially, you're doing that. So you can use assault then if somebody, basically somebody looks like they're going to try to hurt you. You can show they intended to try to cause that touch. They didn't succeed, but they still assaulted you. Okay, that's what that means. The part of assault that generally, though, gets more independent action, if you will, is the first part. And that requires a little more than just an incomplete battery. So let's read that again. The defendant intended to cause apprehension of imminent harmful or offensive bodily contact. Defendant intended to cause apprehension of imminent harmful or offensive bodily contact. So I'm going to underline 2 words in there. Apprehension and imminent. What does the word apprehension mean?
Understanding.
Ms. Grossman, understanding. Okay. Apprehend, they know it's coming. Alert. It also has a slight negative connotation that there's fear. Fear, right? So then assault can occur from the very simple act of, I'm just about to do a battery, but I don't. Doesn't work somehow. And notice that doesn't require any understanding of what the plaintiff was thinking or feeling. Just like battery doesn't, right? In our battery cases, it didn't matter if the plaintiff was scared or not scared or anything, right? What mattered was, did the defendant cause the unlawful touch, pull the chair up, right? That's all that matters. So similarly, the second part of assault, the second definition, which is just an incomplete battery, is the same. It doesn't matter what the plaintiff was thinking. But the other way to cause assault or have an intent for assault has to depend on the state of mind of the plaintiff. state of mind of the plaintiff, right? The plaintiff has to be in reasonable apprehension of imminent harmful or offensive bodily contact. So, what that means then is, in most cases, if you're actually bringing a claim for assault that you want to recover damages from, it's going to be that first one. Why? Because if it's the second one and the battery didn't happen and you didn't even know the battery was going to happen, then you're probably not hurt. You might be, but you know, unless you were afraid, you probably wouldn't bring a lawsuit, right? So it's as if, you know, the Daily Kid goes to pull the chair out from under her, but he doesn't. He misses, because he's 5, falls over. She sits down, and there you have it, right? So it's that first one that is often the separate kind of claim that might come out, you know, without an actual battery, right? And so that's what's kind of going on in the case of Vetter versus Morgan. Vetter versus Morgan. So in this case, I will call on the next person. See, with cards, you can just call on all sorts of people. Trying to get this. Make sure it's here. Yep. I'm going to get this soon, I promise. Mr. Hart, 9 of diamonds. Okay. What happened in Vetter versus Morgan?
So Morgan and his friends pulled up next to Vetter at a stoplight and started basically just harassing her.
Okay.
So like shouting obscenities, they spat on her van, made violent gestures, and threatened her.
Okay. So we have a threat, right? We have actual actions that are aggressive, certainly. And what sort of happens after that?
So once the light turned green, she claims that Morgan veered into her lane, which caused her to kind of run up the road, hit a curb, and then she hit her head on the steering wheel.
Okay. So important thing to note here is she got hurt, right? She actually got hurt. It wasn't just damages from being afraid, right? She was, and you can get damages from being afraid. I'll talk about that momentarily, but she actually had a physical injury as well. All right, now, what I think is a little confusing about this case, and I'm going to sort of pull these apart, is going to your second part, it says when the traffic light changed, both vehicles drove forward. So I'm just going to ask you, and if you don't know this off the top of your head, I don't want to, you know, I'm not trying to like trick you. No, this lawsuit is against Morgan, right? So was Morgan's the one who spit on the window. Was Morgan driving the car?
No.
No. Another person was driving the car. Gaither, right? Now I just bring that up because given the evidence as it's set out here, it seems like there actually might be 2 possible tort things going on. Okay? So let me just pull back for a second and look at that second one. She claims that when she started to pull forward, the car that Morgan was in, driven by Gaither, pulled out in front of her to cut her off, right? And forced her off the road. Okay? Now, that could have given rise, to me it seems, to maybe an assault claim against Gaither. So what would she have to prove in that case? That Gaither, so the second one, intended to cause a touch but wasn't successful, like I'm going to ram into you, or
That's right.
intended to cause her to be scared that they were gonna run into her.
Mention of it in the form.
Yes, yes, okay. So you guys have probably been, you've seen or been in these situations, you've seen people cut other people off and this and that, and cutting off is one thing, literally trying to force someone off the road, or are they really gonna run into you, or, I don't know, that's a whole other thing. So just thinking about that as a whole other thing for a second. What evidence might weigh against finding that Gaither had an intent to hit her car with Gaither's car? It's not in the case, this is just common sense.
She's in a blind spot.
Okay, she could be in a blind spot, that's one thing, yeah, that's common sense, all right. What else?
I think if he wanted to hit her, he could have.
Wanted to hit her, could have.
He was under drug influence.
Could be under the influence, which gets us more into the negligent part, right? What else? Yes.
She wasn't in no training, she went forward.
Okay, she might have been in no training, she went forward, right? That's possible, yes.
What about the control stop the case, because it was 1:30 a.m., so we assume that it was dark, she was by herself in the car, things like that.
Right, right.
She didn't have anybody, or I think
She did
it
not.
was mentioned that even if she calls 911, it's gonna take
Yeah,
time to
yeah.
help her.
And I think this is before cell phones, actually. The other thing is, assuming somebody is not, let's say, on drugs or alcohol or whatever, generally, they don't usually want to hurt their own car. Not saying they wouldn't. Mean people do that all the time, but, just noting out. The point I'm trying to make here is, for some reason, the attorney chose to pursue the assault claim against Morgan and not Gaither. They could have tried both, but the damages, you couldn't get double damages, right? It's the same damage. It's the same damage. So they chose this one. And I think for some reasons it's more obvious. It's what you were saying. There's definitely threatening behavior, actions. In terms of Gaither and driving, we really kind of don't see or know what's actually happening there, right? We just don't know. It's pretty hard to even get evidence about frame of mind or intent, except really all you have to testify is Gaither, right? You can't. Whereas in this case, you do have evidence, and both admit it. Mr. Goodman.
I was just going to say that I have that they actually did settle with Gaither.
Aha! They might have settled with Gaither. Okay, excellent. All right, very possible. There are all sorts of potential reasons here. Now, let's go back to whether an intent for assault was proven against Morgan. The trial court concluded there was no evidence that Morgan threatened or attempted to harm Vedder. He had no apparent ability to harm her because her van was locked, windows were rolled up, no claim of immediate apprehension. Okay, now, where are we getting this? We have gone through the whole trial, right? We've gone through the trial. We have evidence, right? We have her testimony, his testimony, and the trial judge says this testimony, this evidence, does not allow a reasonable juror to find assault. And these are the reasons I'm saying that, because there was no apparent ability to do the bodily harm, and that would cause immediate apprehension. So now we're up on appeal, right? What does the plaintiff claim? The plaintiff claims the judge below erred in directing a verdict and not allowing the case to go to a jury. She says this is a question of fact, not a question of law, right? It's a question of fact for the jury as to whether or not I could reasonably feel threatened, and how quickly I was afraid that something would occur. That's what she's claiming. And here the appellate court agrees with her, right? The appellate court agrees with her. And notes, windows can be broken. I don't know about you guys, but I don't care if my doors are locked. If people are like, screaming or yelling or hitting or what, I would be worried something bad could happen. That's just me. So I'm just an ordinary person, I should be on the jury. I think that. But then the one legal thing we get a legal tidbit here too about the law. Morgan's behavior was so extreme that Vetter could reasonably have believed he would immediately try to carry out his threat. And this is our snippet of law from Restatement Second of Torts. It is not necessary that the victim be placed in apprehension of instantaneous harm. It is sufficient if it appears there will be no significant delay. Would any of you like to volunteer to explain the difference between instantaneous harm and no significant delay? Okay, breaking window. Takes a second or two. Instantaneous might give you get a shock, right? Or the axe, or right, there's no window. Okay, where did we think that? Notice that comes from restatement. Where did that come from? It comes probably from a case where some judge said, for harm to be, immediate, it doesn't have to be instantaneous. It just means there has to be no significant delay, right? And so there you go. It gets into the restatement, and that's what we have. All we know that it means is the best we can figure out. It means something doesn't have to be instantaneous, whatever that means. Like it doesn't have to be that second to have immediate apprehension. It doesn't have to be that second to immediate apprehension. Okay, we're gonna go back to this, and I know I'm gonna let you take the break, and they're getting hungry, but before I do that, have some fun thing for you. So I'm passing on a news story from, I think it's about 2 years ago, and you can read it before you take a break. You can read after you take a break. We're going to take a break until about 20 till, so you can have a little time to read. So I'll just pass these out. Some of our sports fans may have heard of this. Yes, just short. So is it still going around? We have extras. Coming to the back there. Back row. Yeah, we've got extras sitting over there too. Okay, you're on break, but by 17 till 8, have read this. Okay? So take time to read it. Go take a break. Here's something to read. Right. That could be it. I mean, again, that's why I asked you. That's why I asked you. And I trying to see if it's the window, right? If there hasn't been a window, it's instantaneous. The window's got to get. Exactly. But essentially, it's kind of related to the idea that you can't get away. Kind of. And what it can't be, though, is you can't say, I'm suing this person for assault because he sends me a bill tomorrow. It can't be, because you have the option of doing other things to protect yourself. It can happen that way, absolutely. And sometimes you want to plan physical work. So you can have it both ways. It's just on average. Just because you have a good even if you take things away from this, you still have so let's say he didn't believe her, yes, I'll put you in the chair there, but maybe he thought the chair was gonna move, right? So he never says that, so that's why the case is amended. Yes, yes. No, it's, they edit these down, so you have to kind of think about it. You're welcome.
Yeah, she's gonna have to. It's nice because I have, yeah, I actually have.
How are you?
Got frustrated.
Yeah.
Yeah, there's a bunch of questions.
This is why I got married.
Water. I can be honest, like, that does seem to be the dream. I was doing a podcast with a reporter there from last week. Because there's one guy with questions, there's one guy from. Like, I don't know if that was the pictures, you don't know, this is like real bad. Like, yeah, I know it's like that dog utilization, maybe 900,000 acres in places that never did, it's like just that. It's like, yeah, I know, I personally think that's interesting, no, it's pretty big in, New Hampshire, I'm sure Justin.
So, all you have to do is show them that what is on paper is and that you're oh, wait,
Okay, we're gonna start in about 4 minutes, so finish reading the article if you haven't had a chance to yet. Get your food. I was gonna say. That smells. Yeah. Maybe sort of sitting there or then I'll be still. Among my friends, my nickname is always. Yeah, particularly that if I'm blind and So wait, did you guys do this?
No, we started on Tuesday night, but that's all. Yeah, we will, yeah.
All right, let's everybody head towards your seats with food. And we need to think a bit about Ms. Brindle. So, I am going to divide you into some groups now. All right? You're not going to have to move though, so don't worry about moving your food and all that. So I'm going to try to do this with groups of five people, and try to get you as close as I can, but I know it's all going to work. So maybe you five are group one, and 1, 2, 3, 4, 5. Sorry, it's an angle. You were group two, all right? And 1, 2, 3, 4, 5. You guys are group 3. Okay. 1, 2, 3, 4, 5. You guys are group 4. Let's see. Let's do it. 1, 2, 3, 4, 5. Group 5. 1, 2, 3, 4, 5. 6. And started here, right? So then 1, 2, 3, 4, 5. Group 7. Okay. 1, 2, 3. 1, 2, 3, 4, 5. Group 8. 1, 2, 3, 4. Group 9. All right, so there are 9 groups. 5. So 9 groups, okay. Now, it's probably obvious why I have given you this article to read. We have a very famous person who is suing people for a lot of money with a claim of battery, among other claims as well. So, groups 1, 3, 5, 7, and 9, raise your hands. 1 through 5, 7, and 9. You're 9, right. Just make sure you know your group number. Okay, 1 through 5, 7, 9. You need to put your mindset as the mindset of the plaintiff. Groups 2, 4, 6, and 8, you are the mindset of the WTF and the ITF. Now, I'm specifying that at this point, at the beginning, because what I want you to do next, for the next 10 minutes or so, is in your group, discuss together your best case for why the plaintiff has a successful claim of battery, if you're 1, 3, 5, 7, 9, or why the plaintiff does not have a successful claim of battery, if you're 2, 4, 6, 8. So I know it's especially this group, it's a little awkward, but try to just talk as among yourselves as you can. You know, one way of doing this is everybody's read the article, you could have everybody give their own opinion first, and then just decide, yes, just battery. Just battery, just looking at battery, only battery.
tutorial of
Everybody get as comfortable as you can. So, I'm going to start by. All right. So, normally we would start with a plaintiff, but the cards say otherwise. So, I'm actually going to start with a very a preliminary question, I guess, for group 4. You're group 4, right? Yep. Okay, group 4. What are the elements necessary to prove that battery occurred, to establish battery? Any of you can answer.
Well, in general, it's the duty, breach of duty, causation, and damages.
That's a great start. Okay. Duty. Breach of duty, causation, and damages. And just to remind us all, the duty is the duty not to intentionally inflict a touch that is unlawful or offensive. So when you breach that duty, that's what you're doing. So pretty much what we've been talking about our cases is this part so far, right? Group number 4. Is that the only element that might be at issue here?
I'm not sure if I'm answering this correctly, but I guess in terms of looking at defenses, so you have consent, like the
Yeah, not defenses yet, but so we know that breach is one thing we're going to talk about. Is there any other possible thing to talk about? Yes?
I feel like the duty, because they weren't just regular people.
Aha. Okay.
That was actually their job.
They weren't just regular people. Let's come back to that one, because that's an interesting point. Other possibilities, anyone?
certainly, I mean, we talked a little bit about the causation.
Causation, okay. All right. Now, that's great. Thank you for getting us started off. And now we go to group 7. There. You are a plaintiff group, correct? Okay, so how do you claim that she can bring a successful case for battery? And you know what? It's fine to just focus on the breach part at this point, okay?
All right, so then there was intent for the unsolicited contact after she already got punctured a couple of times. She was screaming in pain, she passed out, and still punctured for the vein, ended up, I guess, flat.
Okay, so there was an intent to do a touch. All right. Does all groups agree that there was an intent to cause a touch?
Yes.
So then, what is the issue of dispute between defense and plaintiff? Yes?
Is it gonna be about if it's like unlawful or unauthorized, and then whether it was like an offensive, right?
Okay. Is the question really about, we know that there was an intent to touch, right? There can be sort of no doubt about that. But then is the real question then for the breach part, whether that intent, whether the touch was lawful or offensive. Lawful or offensive. All right, I'm going to go to group number 8, who is on the defense. What is your argument that the touch was not unlawful or offensive? Or is not, yes?
Because it was set by rules, and when the plaintiff became a player, she knew the rules that she would be subject during her career. So she was subject to testing and any other things that under the rules.
Okay, so it was part of the rules. Okay. Can anybody analogize that to when a touch could occur in another kind of sport? Yes?
This is probably a bit extreme, but something like football where you clearly submit to a certain level of content.
Okay, I don't think that's that extreme, right? We know that generally in football, you don't have claims of battery. Why? Consent. Everybody's going to the consent. You're getting to the defense, the consent. I want to stay on the prima facie case for a moment. You're all right, though. I mean, you're correct. Consent is a big thing. But let's just stick to the prima facie case. Let's just talk about that touch. Unlawful or offensive. You're saying not unlawful or offensive because it's part of the rules. And I think you said she knew the rules. Okay. Let's hear from a plaintiff group. Number 3.
One.
Wow, you're 1. Okay, even better.
Well, we are for the plaintiff, but we think that they could say, the defendant could say that the plaintiff is too sensitive because vaccination is, the needle is just a routine medical procedure.
It is, but you're in group number 1, right? So you represent the plaintiff. Right. So, okay. All right. So she's too sensitive. Does that matter for battery? It does not. It does not. Remember, you take the party as you find them. Now, it does matter for assault, because there's that reasonable apprehension, right? But it doesn't matter for battery. So again, the piano player person, the student. Okay. So,
I'll say something
yes.
for the plaintiffs.
Yes,
in
okay.
our favor. The restatement of torts said something about offensive touch, and if you know that that's going to be offensive, even if ordinarily it wouldn't be offensive, that still falls in the realm of an offensive touch.
So the argument is they know it's offensive?
To her, because she's had these problems before, and
Ah.
she requested.
This is good. This brings up a very interesting point. It turns out that the defendant, whether they know or don't know, doesn't matter. So a way to think about battery, but it's important to bring this up. It's the intent to do the touch, okay? So your intent is to the touch, intent, touch. That's it. Then over here all by itself, the touch has a quality, right? It's either offensive and harmful or it's not. Now, does the defendant's intent ever affect that? Yes. Yes, it does, right? Because if you know something is going to hurt somebody and they aren't agreeing to it or whatever, that can turn the touch. But the defendant doesn't have to know or not know, right? Because remember the piano player guy. He obviously didn't think that was offensive, but it was, right? Because it was harmful. Yes?
Well, I think for the breach, they do as a, for giving the blood or for the test, they have a right to, touch her, but with dignity and respect.
Right.
And she's claiming that they were acted with disrespect.
Okay.
And that is a problem.
Okay, another good plaintiff's argument. Does everybody sort of get that wrinkle? That while it is part of the rules, she knows the rules. In this case, she may be different because it is disrespectful. Now, I'm not sure that's true or not, but that's a good argument. Let me show you a way it absolutely could be true. All right? Imagine, if you will, that you're playing football, all right? Everybody knows you can be hit or whatever, but all of a sudden, coach is mad at a particular player, right? And orders everybody to gang up on that player. Does that change anything? It seems like it could. Right? So yes, the defendant's intent could have some impact. Okay. Yes.
I think there was also something in the restatement about offensive touch, and that it was offensive if it also wasn't unduly burdensome for them to refrain. She gave them alternatives that would not make it unduly burdensome.
Unduly burdensome
Therefore,
to
it was offensive.
refrain. Very interesting point. And that was with a sensitive, a person with particular sensitivities. Unduly burdensome to refrain. Good point on that. Why did they claim they couldn't do her alternative? What was her alternative suggestion?
You suck it through the skin.
Capillaries. Why did they claim they couldn't do that?
It wasn't validated.
It wasn't validated. Why are they doing blood testing at all? Drug testing, which has been a problem in sports and athletics. Okay. Question, just by show of hands. How many of you think it is more likely than not that she can prove the prima facie case of battery? Yes, first. Let's see the yeses. Okay, let's see the no's. Fairly evenly split. Do you want to know what the right answer is? So do I. That's why it's a case. But please save this because we're actually going to come back to it when we talk about defenses. Okay? All right. We don't have that much time left, but we do have enough time to talk about, and go back to your seat, to talk about a couple of the other cases. So let me just say,
Nobody's here.
let's talk about false imprisonment for a moment. This case, Ernst v. Winterberg, actually comes out of a very interesting fact pattern that has come up again. Turns out this is in the early 70s. This is all about groups, one group saying they think that there are, what's the word I'm looking for? Voting fraud. Voter fraud, right? And this is something we hear in our political parties all the time, but this is back 40-something years ago. And it's about that. So we have a group worried about voter fraud, okay? And one of the things they're worried about is somebody's voting in a location that's not their address, all right? Which is not what you're supposed to do. Okay. So they go to an apartment building, and their purpose, apparently, is to check addresses with the voter rolls, or names on the mailboxes, and see what's there. Okay, so that's kind of the setup. They go to this multi-unit residential dwelling within this particular alderman's district. The plaintiff's ultimate purpose was to purge the voters list by challenging people whose names were not on the mailboxes. Now, when they reached it at 4:30, they entered through the outer door into a vestibule area. So it's not a secure building, right? It's a multi-unit building. So it doesn't sound like there's a particular trespass. People can come and go. And they were checking, then Winterberg entered and asked what they were doing. They told her they were looking at purging voter lists. She became very agitated and told the plaintiff she did not want them in her district. Interesting. So I'm bringing this back to the voting kind of thing, right? And I think that's important to sort of think about this, is how a case like this gets here, right? Because even if you read it in the way most favorable to the plaintiffs, they were delayed at most 5 minutes, right? But they get these damages. And so what this is really kind of about is who has the right to do this and be where and be there. And there's anger, right? There's anger on at least on the side of the defendant. So she said, now will you identify yourself to the police? So what we have in evidence is she told them to leave. Then she changed her mind and asked who we were, and then said they didn't identify themselves, and she said, well, I want you to wait here, or I want to call the police, willing to identify themselves to the police. So this is kind of, you can sort of see it escalating. What are you doing here? We're purging, illegitimate voters like you have in your apartment building. Who are you? What are your names? We don't have to tell you our names. Well, are you going to tell them to the police? Yes, we would tell them to the police, right? So she calls the police. Okay. And we get here, she positioned herself in front of the outer doorway. She did not brace her arms, she testified. She said it's her versus 3 of them, and plaintiffs sue for false imprisonment. All right, let's go to the law of false imprisonment. It is an intentional tort. It is defined on page 28 of this case. It's an intentional, unlawful, and unconsented restraint by confinement. All right? Unlawful and unconsented restraint. So that is very similar, if you think about it, to battery. Right? It's an intent to restrain movement, but that the restraint is unlawful. Like the touch is unlawful. So what that suggests is there are some restraints that are lawful. What are some of those restraints? Can you think of any? What are restraints that are lawful?
Seatbelt in your kid.
Seatbelt in your kid, that's lawful.
If you steal something in the store, they can.
Sometimes in the store they can restrict your liberty. That's an open case. Yes?
Not too much time.
Not too much time. Okay, right. Yes?
I don't actually have the answer about citizen's arrest.
Citizens arrest.
It's a lawful restraint.
Is citizen's arrest unlawful restraint? Turns out it depends on whether you have a reasonably valid belief or not. Belief. Reasonably valid belief. So in other words, yes, you can't, there is such a thing as a citizen's arrest. Basically it means that one individual has a lawful right to confine another individual, but it's only in very specific reasons related to potential criminal conduct. Yes?
Just confinement under court order.
Confinement under court order. That's absolutely legal, right? So it could be in a jail or some other kind of thing. You've seen people confined if they can't take care of themselves, right? Or confined if they're even mental health issues or physical issues, right? So there can be certain kinds of things that may be allowed. Now, so the element here is unlawful. So generally, if you have, so it's pretty clear that adult to adult, it's unlawful if basically somebody doesn't consent and can't get away, essentially, basically, right? The person has to know they're being confined, right? It can't just be you drew a box around them and you're like, stay in the box the whole time. That's not it. So here the question is, the plaintiffs state, is there enough credible evidence to support the